Good morning, everyone. I'm thrilled to welcome everyone to session 1, where we'll be discussing the meaning of a 21st century ERA. For those of you who are new to the ERA, I will briefly set the stage for this conversation. Women and advocates have been trying to put sex equality in the Constitution since this country's founding. The ERA has been nearly 100 years in the making, first introduced in Congress in 1923 on the heels of the passage of the 19th Amendment. The ERA is straightforward in its language, stating, equality of rights under the law shall not be abridged or denied by the United States or by any state on account of sex. Yet, in 21st century America, this simple phrase has become a radical notion for some. The United States has the most difficult constitution to change, and yet the ERA has met the extremely high bar set out in Article 5 of the Constitution, which governs the amendment process. Congress passed the ERA by 3/4 majority vote in 1972, with overwhelming bipartisan support. And over the past 50 years, the ERA has been ratified by legislatures in 38 states. In fact, the ERA is the only proposed amendment that has met all constitutional requirements that is not officially recognized in the Constitution. If all constitutional requirements have been met, why isn't the ERA widely accepted as the 28th Amendment? The main obstacle is the 7-year time limit for state ratification that Congress originally included in the preamble of the resolution approving the ERA, which expired in 1979. Another potential obstacle is the handful of states who had previously ratified the ERA and have voted to rescind their earlier ratifications. There's nobody better situated to tell us about the important developments in the ERA and what lies ahead than this distinguished group of speakers. Their accomplishments are so vast that my brief introductions cannot do them justice. You can find their extended bios in our symposium materials that we shared. Now, it is my distinct pleasure to introduce Virginia State Senator Jennifer Mcclellan. Through her tireless advocacy and inspiring leadership in Virginia, Senator Mcclellan was instrumental in Virginia's 38th and final ratification of the ERA. As the first House member to be pregnant while in office, she's been a fierce protector of women's reproductive rights, children, and families. I want to extend a warm welcome to my hero, Senator Mcclellan.
Thank you, Ting Ting Chang, and good morning, everyone. Thank you for having me. First, I have to apologize that I will not be able to stay for the entire panel, but the Virginia General Assembly is in its final week and couple of days of this year's session, and I have to head to the Senate floor shortly, but I did not want to miss today's symposium or this panel in particular, setting the stage for the history and revitalization of the Equal Rights Amendment. I wanted to start by sharing that my journey to carrying the resolution in the Senate to make Virginia the 38th state to ratify the ERA really is rooted in my own family and life history and the intersectionality of being a Black woman in America. Because I'm not just the legislator that led the Senate resolution to ratify the ERA, I also come to this body as the daughter, granddaughter, and great-granddaughter of educators, domestic workers, community leaders, civil rights activists who fought against the legacy of slavery and Jim Crow. I am here as someone whose mother, grandmother, great-grandmother, aunts were all domestic workers who still, in some cases, don't even have access to the minimum wage because of decisions made over almost a century ago. I'm here as the first member of my family. My generation is the first generation in my family to be born after Jim Crow legally ended. And I was born in the same year that the ERA passed Congress. And yet I find myself still fighting the same fights that my mother, my grandmother, and my great-grandmother fought. I'm here as a mother who doesn't want to leave those fights to my children, Jackson and Samantha. And the history of my family and the history of the Commonwealth of Virginia, frankly, is one of facing inequities and working to create a better and fairer world for the next generation. So a little deeper into my own family history. 120 years ago, my great-grandfather, who was born on a plantation 4 years after emancipation, had to pass a literacy test and find 3 white men to vouch for him just to be able to register to vote. Yet my great-grandmother couldn't. My grandfather had to pay poll taxes. My mother did not vote until after the Voting Rights Act of 1965. So my father, while at the age of 22, could pay a poll tax and vote. My mother did not vote until well into her 30s. So I carry those legacies with me into the Virginia House of Delegates when I was elected in 2005, and when I came into a chamber that only had 16 women. And I definitely felt the imbalance when I became the first delegate to be pregnant while in office, and I was asked by a colleague if I was going to retire, even though another delegate elected the same year as me, his wife was pregnant, and he was not asked if he was going to retire. So for my family, my Commonwealth, and my country, it's been a long march towards equality. This march has included women of color from the beginning, but often we have been the last to benefit from that work. Black women were part of the suffragette movement, including the founding members of my sorority, Delta Sigma Theta Incorporated, who their first public act after being founded in 1913 was to march in the suffragette march in Washington, even though they were told to march in the back. Black women have been in the middle of the civil rights movement, and in the March on Washington in 1963, didn't have a speaking role, but were there. Women of color have also led the way for ratification of the ERA, including Representatives Shirley Chisholm, Patsy Tokomoto, Mink, 50 years ago when the House passed the ERA. And indeed, Virginia's ratification was led by multi-generational Black women, Senator Mamie Locke and myself, Boomer and Gen X in the Senate, and former delegate Jennifer Carroll Foy, a millennial, in the House. Nevada's ratification was led by Senator Pat Spearman. Other women of color have been pushing their states to ratify the ERA, including Arkansas Senator Joyce Elliott, Florida Senator Audrey Gibson, North Carolina Representative Carla Cunningham, South Carolina Representative Gilda Cobb Hunter, just to name a few. So I was proud to help lead Virginia to become the 38th state to ratify the ERA with bipartisan support. And given our history, it was poetic justice that Virginia was the state to put the ERA over the top. Because let's go back to the founding of Virginia, which also was the founding of what became the United States. In 1619, the men of Jamestown understood that for Virginia to become a permanent settlement, they needed women. So they actively recruited women to, quote, make wives to the inhabitants. And in May of 1620, the first 90 women arrived in response to that call. And when they got here, their rights were surrendered to their husbands. They could not vote, they could not hold public office, they could not control their own property. And African women and men who arrived in 1619 were considered property and had fewer, if any, rights. So, by the way, that all happened months after the first representative democracy was founded at Jamestown, the Virginia House of Burgess, which eventually became the body that I sit in now. So in 1776, as Abigail Adams wrote to her husband when he went to the Continental Congress, imploring him and his fellow delegates to remember the ladies and be more generous and favorable to them than their ancestors, you know, there was a long history of women not being treated as favorably. Unfortunately, the founding fathers at the Continental Congress didn't listen to Abigail. And over the past 245 or so years, we have made progress, but slowly. And true equality under the law for women, and especially women of color, has been elusive. That is all why I stepped up in 2020 to carry the resolution in the Senate. I've always been supportive of ratification of the ERA, and there were efforts way before I got to the General Assembly and throughout my time here. But what really sparked me to step forward and help take the lead was that in 2019, as I sat in a Senate committee waiting to present another bill, that year's version of the ER ratification was being heard. And I noticed the room was packed, but the room was packed with mostly white women over 50. The only people of color in that entire hearing room that day were myself, Senator Rosalind Dance, waiting to present another bill, Senator Mamie Locke, who sat on the committee hearing the bill, and one Asian American woman there to support ERA. And I looked around the room and I thought, why aren't we here? Why is this room not filled with young people? Why is this room not filled with women and men of every generation and every nationality and every color? And so when that resolution died that year, we went to work mobilizing young women and women of color. And we found out a couple of things. First, we found out a lot of young women particularly thought the ERA was already the law. So they didn't think that they needed to fight. A lot of women of color thought, well, that's not something for us. And yet for all the reasons I just mentioned, given the intersectionality of racial and gender discrimination, we had the most to gain. And so we went to work. We went to work building a grassroots coalition that was bipartisan, that was multi-generational, multiracial, and did everything from a bus tour to visiting college campuses, to petition drives, to mobilizing local governments to pass resolutions, encouraging the General Assembly to ratify the ERA. And that all worked in 1 year. In 1 year, we went from a Senate committee killing the ERA ratification and the House not even hearing it, to Virginia becoming the 38th state to ratify the ERA. As part of that bus tour, we talked about, and what helped mobilize people was talking about the impact that the ERA would have on access to abortion, on access to reproductive health and healthcare, health insurance, ending pregnancy discrimination, addressing maternal mortality, reproductive health disparities, achieving pay equity, finally achieving paid family medical leave, expanding access to childcare, and more. We talked about how the rules were different. If you faced racial discrimination on the basis of race, the rules were different in looking at that discriminatory law than if it was discriminatory on the basis of gender. So we made history, and then we waited. With the ratifications in Nevada, Illinois, and Virginia, states have done our part, we should be done. But we're waiting for the National Archivist to do his job by certifying the ratification and putting the ERA in the Constitution. We're waiting for Congress to take whatever action may be needed, although most of us don't think they need to do anything. And we wait for the US Constitution to join the over 100 constitutions across the world, including every constitution adopted since World War II, in adding gender equality. And I still wait. I wait for the moment that I can tell both my son Jackson and my daughter Samantha that they finally will face equality under the law, no matter what. And so that's why, even though I've done my part, many of you have done your part, there's still work to do, and we cannot give up. I remember being on that bus tour, and we were in the town I grew up, and my 100-year-old Sunday school teacher, who happened to be a Black man, stood up and said, I don't understand why it has taken so long. I was a baby when the ERA first was introduced. I don't understand why it's taken so long. And frankly, neither do I. So with your help, we shouldn't have to wait any longer. My children and your children should not have to fight this same fight. It is time to put equality for all equality under the law on the basis of sex in the US Constitution. And hopefully I'll be able to stay for a few questions, but if you see me jump off, it's because I've got to go and do roll call in the Senate. But thank you all for having me.
Thank you, Senator Mcclellan. Now it's my honor to introduce David Posen, Vice Dean for Intellectual Life and Charles Keller Beekman Professor of Law at Columbia Law School. Professor Posen's scholarship on the history and ambiguities of Article 5 in the constitutional amendment process has been groundbreaking. His writing has helped inform Congress and the executive branch and has been cited by ERA advocates as a game changer. Welcome, Professor Posen.
Thank you. Can you release my video? Hi, everyone. Thanks so much to Ting Ting, to Catherine, to the Columbia Journal of Gender and Law for putting on this wonderful event, and to Senator Mcclellan for her inspiring remarks and leadership on this issue. I'm honored to be here to discuss this important matter with such a distinguished group. I want to say at the outset that I don't consider myself any sort of scholarly expert on the ERA specifically. My knowledge of the ERA's legislative and social history pales in comparison to that of, say, Julie Suk, my amazing co-panelist who will speak soon. I've been asked to speak on this panel instead because of some work I've been doing recently on the broader history of Article 5 amendments from the founding to the present. So rather than purport to mansplain the ERA to anyone here, let me try to spend my time reviewing that broader history of Article 5 struggle, and then suggest some lessons it may hold at the end for where we are now with the ERA. So together with an academic fellow here at Columbia named Tom Schmidt, I've been exploring recently the history of Article 5 amendments leading to this paper that Ting Ting was generously mentioning. And what did we find in this study we did? Let's start with the text of Article 5. Article 5 of the Constitution, as everyone here probably knows well, sets forth the rules for formally amending the canonical document that we call the Constitution. There are a few different pathways to amendment that Article 5 allows for, but the primary pathway, and the one we've always used, involves an amendment being proposed by 2/3 of both houses of Congress and then ratified by 3/4 of the states through the legislatures or conventions. Legal scholars routinely describe this amendment rule as an unusually clear and constraining provision of the Constitution. 2/3 plus 3/4, those are high hurdles, of course, but what could be more straightforward than that scheme for rewriting the document? Indeed, a unanimous Supreme Court wrote in a 1931 opinion that, and I quote, "A mere reading demonstrates that Article 5 is clear in statement and in meaning, contains no ambiguity, and calls for no resort to rules of construction," end quote. Yet, while the language of Article 5 may seem straightforward, in reality, it raises a long list of fundamental puzzles. Just consider some of the following questions about Article 5. When Congress proposes an amendment, how long does it remain pending and available for state ratification? In perpetuity, unless Congress specifies otherwise? If Congress wanted to specify otherwise, how might it be allowed to do so? Can Congress impose additional requirements on the state ratification process, say requiring a supermajority vote threshold in the states as in Congress? Can states ratify their amendments through referenda? Do state governors get to veto their legislature's votes on amendments like they would an ordinary bill? Does the US president at the federal level play any role in the amendment process, including potentially exercising a veto? What about the substance of amendments? Is there anything amendments cannot change about the Constitution? My colleague here at Columbia, Philip Hamburger, has written that the framers of the Constitution deliberately chose the word amendment rather than say a word like alteration to imply that amendments could only be limited to an incremental perfecting role and not fundamentally transform the constitutional order, although many dispute his view of that. Perhaps most important, who gets to decide whether and when an amendment has satisfied Article 5 and become a new part of the Constitution? The text of Article 5 itself does not answer any of the questions I just listed or many more. So it turns out there's fundamental silences and ambiguities in this provision that tells us how we can update our canonical legal text. Well, okay, you may be thinking at this point, the language of Article 5 may be ambiguous or silent in various respects, but surely the law of Article 5 is much clearer at this point. Surely over 200 years of historical experience with Article 5 has yielded lots of judicial decisions and congressional executive settlements that have filled in those ambiguities and gaps and concretized the meaning of Article 5 today. Well, it turns out that's just not the case, or at least much less so than you might expect. For those, let's start at the beginning. For those who identify as originalists in the way they interpret the Constitution and want to know what the people who wrote and ratified Article 5 thought it would do, how it would answer all these questions, there's very little to go on. The framers and ratifiers of the Constitution barely spoke to any of the questions I just enumerated. As one scholar observed in a major study of the Philadelphia Convention, in which Article 5 was drafted, I'm quoting this scholar, "The consideration of amending procedures was one of the least adequate of convention debates," end quote. There's just not much discussion about what Article 5 was supposed to mean in Philadelphia. And then in the subsequent state ratification process of the Constitution, questions about the meaning of Article 5 barely came up. So there's not much for an originalist to go on. What about all the history since? All the amendments, the 27 now, that are widely seen to have become part of the Constitution. What can we learn from their story? Well, it turns out that the overwhelming majority of the 27 amendments we now count as part of the Constitution have faced credible legal challenges to their validity, to their compliance with Article 5, that were beaten back by proponents at the time that they were issued, but in many respects have never been definitively resolved, leaving a legacy not of clarity and concreteness about what Article 5 means, but rather one of contestation and ongoing confusion in the legal community. Let me quickly run through what this looked like across the amendments. The first 11 amendments, including the Bill of Rights, were not presented to the president, even though another part of the Constitution, Article 1, Section 7, Clause 3, states that, and I quote, "Every order, resolution, or vote of Congress shall be presented to the president and must be approved by the president before it takes effect." Some scholars, particularly textualists in the way they want to interpret the Constitution, have said that the first 11 amendments, therefore, and others subsequent, violate this provision because they weren't presented to the president. The 12th Amendment, which came next, sets rules for electing the president. That was passed by less than 2/3 of the full Senate. It was passed only by 2/3 exactly of a quorum of the Senate, not the full body, even though that arguably conflicts with the supermajoritarian letter and spirit of the Article 5 voting rules. The framers of the next set of amendments, the 13th, 14th, and 15th, the Reconstruction Amendments, which of course abolished slavery and established new guarantees of equality and due process, they took a number of highly unusual maneuvers to prevent obstruction by former secessionists, arguably coercing the southern states into ratifying as the only way to get those amendments through. Many constitutional scholars agree with the assessment of Bruce Ackerman when he wrote some years back that those various maneuvers taken to make sure we could get the Reconstruction Amendments in there amounted to nothing less than a naked violation of Article 5. That's Ackerman's phrase, a naked violation of Article 5 for the amendments that are really the most foundational we have, amounting to a second founding for the country. The 16th Amendment authorizing a federal income tax wasn't nearly so dramatic, of course, but the states actually ratified inconsistent versions of the text of that amendment, even though there are plausible arguments that states should have to ratify identical language for that language to become recognized as a new part of the Constitution. The 17th Amendment, providing for direct election of senators, was passed by the US House and Senate during different legislative sessions, not the same Congress, as was the 13th Amendment, by the way. Even though some scholars, including Sai Prakash in a recent Harvard Law Review article, argue that, like bills, amendments must be passed during the same legislative session to be valid. The 18th Amendment, giving us prohibition, banning the manufacture and sale of alcohol, was initially invalidated by a district court on the ground that it should have been taken up by state conventions rather than state legislatures. Prohibition was in turn repealed by the 21st Amendment, which sparked yet another round of fierce debates about how state ratifying conventions could operate. The catalog of controversies just goes on and on when we look at the amendments that we now treat as part of the Constitution. In our own time, the most recently recognized amendment, the 27th, which prevents Congress from giving itself a pay raise before an intervening election, was ostensibly ratified in 1992, over 200 years after it had been proposed by Congress along with the Bill of Rights. Way back in 1921, a unanimous Supreme Court, including justices like Oliver Wendell Holmes and Louis Brandeis, suggested that what we now call the 27th Amendment was already dead and unrevivable in 1921. And numerous prominent constitutional scholars have argued that in light of the extraordinary delay between its proposal out of Congress and its ratification, the so-called 27th Amendment should be treated as a bad joke. And yet, Congress has recognized the 27th Amendment, and virtually every published version of the Constitution that we now have includes it. So what does this tell us? What does all of this tell us about our question for the symposium today and the status of the ERA? Well, as you've heard from Ting Ting in her opening remarks, the ERA raises some tough Article 5 questions of its own, unresolved Article 5 issues of its own. On the one hand, it's won approval of 2/3 of the House and Senate and 3/4 of state legislatures, and in that sense looks like it's checked all the boxes indicated on the face of Article 5 to be a valid amendment. On the other hand, there are a number of complications, including that Congress tried to put a deadline in the resolution sending the ERA to the states when it initially did so, even though it's not settled that Congress can impose a deadline in that manner, not in the text of the proposed amendment itself, but in the accompanying resolution. Of course, that purported deadline expired before several ratifications came in, and further complicating matters, we now have a number of states that have voted to try to rescind their prior ratifications, even though it's not clear that that is allowed under Article 5. So what does the broader history that I just canvassed suggest for the debate we're having now about the status of the ERA? I see two main lessons in the history, and I'll try to briefly state them, and others on the panel may have more they want to extrapolate from our experience of Article 5. So the first lesson, I think, is pretty straightforward, which is that for all that is distinctive about the ERA saga, there's nothing distinctive or unusual about the legal uncertainty that surrounds its status right now. On the contrary, as I've tried to explain, attempts to amend the Constitution have always generated difficult legal puzzles and messy political debates. Critics of the ERA like to say that it's not clearly satisfied Article 5 and therefore is suspect. Well, the same could be said of nearly every recognized amendment that we have. So I think that's lesson one. Just the fact that the ERA does not clearly and undeniably conform to Article 5 shouldn't scare us. Getting an amendment recognized in our system has always involved a fair amount of legal creativity as well as political will, of course. Put a little more abstractly and provocatively, we might even say that our Constitution, our written Constitution, isn't so much a collection of texts that have passed through a unique legitimating process as it is a collection of texts that Americans agree to regard as the Constitution, despite wide variations in and serious questions about the manner in which they were added. The sociological legitimacy of an attempted amendment, in other words, the sense in which it's perceived by the American public as part of the Constitution, has not really been a function of its fit with the language or letter of or law of Article 5, at least not in any mechanical way. Okay, the second lesson is, I think, perhaps a little less obvious and more debatable, but I think the history also suggests that the fate of the ERA should now rest principally in the hands of Congress. Because the law of Article 5 is so unsettled, as I've tried to explain, controversies over the status of amendments are going to continue to arise. It's not just the ERA. There are a number of other controversies actually alive right now, and more are going to come in the future. It is therefore crucial, I think, that we have some means of resolving these controversies peacefully and authoritatively. And it seems to me that Congress is in the best position of our federal organs of government to do that. The president has never played any significant role in this domain. There's just no history and there's no textual basis to think that the president would be the key actor here. Well, what about the courts? We generally look to the courts to resolve constitutional controversies. The Supreme Court has actually only addressed the meaning of Article 5 a handful of times squarely, the last time over 90 years ago. And many of the court's statements on Article 5 are just dicta, unreasoned assertions, or both. More than that, several of the statements that the court has made about Article 5 have been blatantly contradicted by subsequent practice. Just to give one example, the court in the national prohibition cases in 1920 said that amendments need, and I quote, a vote of 2/3 of the members present, end quote, in a chamber of Congress to get out of Congress. And yet the 22nd Amendment was approved by the House in 1947 without clearing that threshold. So we don't actually have a robust history of the court telling us what Article 5 means and people complying. When you try to change something as foundational as the Constitution itself, it turns out the court is not well equipped to definitively resolve the matter. And to be clear, I think it's a good thing that the court has largely stayed away from the Article 5 domain. All the more so now that the court has been captured by a right-wing party. But even if I liked the court today better than what we have, I still think this isn't a domain in which the court should control the law for all of us. As 7 justices wrote in the 1939 case, Coleman versus Miller, disputes over Article 5 are often going to involve so-called political questions, questions that are not well suited to judicial review. Many Article 5 disputes actually don't give rise to justiciable controversies at all, at least not in any timely fashion. The court's precedents in the area are sparse and not well ordered. And questions about Article 5 are often going to involve highly charged, legally underdetermined judgment calls, which risk taxing the court's competence and its own legitimacy. I think this leaves Congress as our least bad option. Consistent with the text and history of Article 5, I think Congress should understand itself to have the power to change the deadline that it originally sought to impose on the ERA. I think Congress should understand itself to have the power to decide how to treat the most recent state ratifications, including Virginia's, we just heard about, as well as the attempted takebacks from those states that initially voted to ratify the ERA and have tried to rescind that vote in the years since. And more generally, I think that Congress, not the courts, should be seen as the primary arbiter of an amendment's validity when there's a question about it. None of this, of course, resolves exactly what Congress should make of the specific issues raised by the ERA and Article 5, nor does it resolve how Congress should practically move forward now to try to get the ERA recognized as 28th Amendment. I'm sure we'll be discussing that later in the panel and later today and tomorrow. The point I'll close with is just this institutional one, which is that we shouldn't want or expect anything good from the courts on the question of the ERA's validity, nor I think should we rivet attention on executive branch actors like the archivist. I think instead we should think of Congress as the key body to push the ERA forward in light of the historic role Congress has played doing that, and in light of the kind of irreducible messiness of Article 5 fights that our history shows us we've always had, and the ERA is the latest and a particularly important example thereof. Let me stop there, and I look forward to the further discussion.
Thank you, Professor Posen, for showing us that the ERA's amendment process represents the rule and not the exception in our history, and for providing your expert analysis for the path forward. Our next distinguished speaker is Michelle Callan, who recently served as Virginia's 7th Solicitor General, where she led the 3-state litigation strategy seeking recognition of the ERA in federal court. Michelle currently serves as Special Litigation Counsel in the Office of General Counsel of the United States House of Representatives. Michelle, we're so honored to have you on this panel.
Thank you so much for having me, and I'm thrilled to be here. Given my current role, I have to say at the onset that everything I'm saying is purely in my personal capacity, and I'm going to avoid speaking about anything related to Congress specifically and the ERA. But I'm thrilled to be here both to speak about our litigation and Virginia's role. So as Ting Ting mentioned, I was in the Virginia Office of the Solicitor General at the time that Virginia ratified the Equal Rights Amendment. And by a little bit of background in terms of kind of Virginia, in the Virginia Office of the Solicitor General, Virginia had not had a female Deputy Solicitor General until I arrived. And when I took over as Solicitor General, Virginia had never before had a female Solicitor General. And that gives a little bit of context about why it was so important and so meaningful that Virginia was the 38th state to ratify the Equal Rights Amendment. Virginia hasn't had the best history when it comes to equality. For example, Virginia didn't ratify the 19th Amendment until 1952. So the fact that we were the state that from our perspective and from our litigation's perspective, brought the ERA over the finish line was particularly meaningful to us. When Virginia ratified in 2020, we had somewhat of an expectation that the Trump administration would not support the ratification of the Equal Rights Amendment, would not recognize our ratification. As some of the prior speakers mentioned, appended to the Equal Rights Amendment in its proposing clause was language setting forth a 7-year deadline that was extended, but that had long expired by the time that Illinois, Nevada, and Virginia ratified the Equal Rights Amendment. And so given that, and given some rumblings about what was going to happen, it wasn't surprising that around the time Virginia was gearing up towards its ratification, the Trump Office of Legal Counsel issued an opinion saying that the Equal Rights Amendment was no longer live and that the 3 states that ratified after the deadline, that those ratifications did not count. And what happened after that is that the Archivist of the United States, who is tasked with certifying and publishing amendments when all the requirements of Article 5 are met, the Archivist followed the OLC's opinion and did not certify and publish. So we stepped in and the 3 states whose ratifications were not being recognized sued in DC federal court. And the defendant in the case was the Archivist of the United States. And the relief sought, we brought a mandamus claim seeking for the Archivist to certify and publish the ERA. We found it particularly meaningful that our office led the charge of the litigation because Virginia's history with equality is fraught, I guess, to say the least. Of course, folks know Richmond was the capital of the Confederacy. Virginia's Attorney General argued the wrong side of Brown v. Board. And even in recent years, Virginia defended the Virginia Military Institute's exclusion of women. And so the fact that we were able to play a key role in the 3-state litigation, challenging the Archivist's refusal to certify and publish, was really meaningful to us. Soon after we filed our lawsuit, there were 5 states that sought to intervene to oppose our position on the Equal Rights Amendment. 3 of them were states that ratified the ERA and then have purported to since rescind, and 2 of them were states that never ratified. While their intervention motion was pending, the Department of Justice filed a motion to dismiss the case, which we opposed. And then eventually the intervention motion was granted. And so the interveners filed a motion for summary judgment. We opposed that motion and then moved for summary judgment on our own on the theory that the case only involved legal issues, not factual issues. After a long time pending and no oral argument, the district court issued its decision, essentially holding twofold. One, that the 3 states suing lacked standing because they didn't have a cognizable injury. And then second, relying on the deadline, basically held that the archivist had the power and the ability to conclude that the state's ratifications did not count in light of the deadline. And therefore we couldn't obtain mandamus relief. We appealed that decision and filed our opening brief in the DC Circuit, and the interveners and the Department of Justice's brief is due tomorrow. Unfortunately, while soon after our opening brief was filed, I had to leave my time in the Virginia Solicitor General's office because, in light of the Attorney General, who was my boss and I was one of his political appointees, and not winning re-election, Virginia switched hands, and so I withdrew from the case. Since the new administration has taken over, the new Attorney General has decided to withdraw Virginia's participation in the case as a whole. I think as a practical matter, probably doesn't make a big difference for the litigation itself, because Illinois and Nevada are pursuing the case. And so structurally, it's in the same place that it is without Virginia as a plaintiff. I'd like to speak a little bit about Article 5, because it is really fascinating. You would think that we kind of are set, or that there's a lot more guidance about how to amend the Constitution. But as we've learned earlier, there really isn't much case law on Article 5. It's interesting to think about the amendment process in the context of the founders, because it was something that was really important to the founders at the time that they were drafting the Constitution itself. Thomas Jefferson, for example, said that emphasized the necessity of amending the Constitution by successive generations, saying, quote, "We might as well require a man to wear still the coat which fitted him when as a boy civilized society, the coat which fitted him when a boy as a civilized society to remain under the regimen of their barbarous ancestors." And the idea is that the coat we wear as children don't fit us as adults. And so under that same principle, it's important to be able to amend the Constitution for future generations. And that's particularly important with regard to the ERA, for example, because it is widely supported in the United States. Sex equality is something that's widely supported. We've only, if you don't consider the ERA ratified, aside from the ERA, we've only amended our Constitution once in the last 50 years. And just about every industrialized country has an equal rights amendment. In fact, when we advise other countries, when they're drafting their constitutions, we encourage them to have equal rights amendments in theirs. So the fact that we struggle so much to amend the Constitution is particularly meaningful. Another thing I'd like to say about Article 5 is that it sets forth equal roles for states and Congress. It doesn't give a role to other branches of government. And that matters in terms of how we analyze both kind of the deadline arguments and the rescissions. With regard to the deadline, the Article 5 gives Congress very specific roles, but doesn't empower Congress to impose, external constraints on the states when they're ratifying. In the past, the way that Congress has set forth deadlines is it did it in the text of the amendment, which then means that the states themselves, when they're ratifying the amendment, they also ratify the deadline. And so if a state ratifies an amendment after the deadline, that in the text of the amendment, it kind of becomes inoperative on its face, but it becomes part of the Constitution itself. I think also with regard to rescissions, there really isn't much case law on point, but it's important to note that rescissions have never been recognized. There have been states that have tried to rescind prior ratifications, and they've never really been recognized. A lot of people, or some people, think that we need to start over with the Equal Rights Amendment, but it's important to think about whether or not that's feasible. Even though the ERA is overwhelmingly popular among Americans, for example, a 2016 poll showed that 94% of people said they would support an amendment to the Constitution that guarantees equal rights for both men and women. And in fact, 80% of people in the poll mistakenly believed that men and women were already explicitly guaranteed equal rights. So it would seem like not a big deal to just start over. But Justice Scalia actually pointed out that it would take, he estimated that it would take something like only 2% of the population to kill a constitutional amendment. And so one of the interesting things about the ERA, aside from equality and the ideas underlying it, which are extremely important, is what does it mean about our society and where we are as a country that we really struggle to amend the Constitution, and that there's even this debate right now about whether or not we can recognize that our Constitution will recognize the equality of both men and women. So I'm really excited for this discussion, and both to talk about the details of Article 5, but also the meaning of the Equal Rights Amendment and what that really, what that can mean in today's one, whether it should be recognized, and then what it would mean for today's society. So thank you so much for having me.
Thank you, Michelle. We're so grateful for your efforts on the litigation. Our next speaker is Julie Suk. She's a professor of law at Fordham Law School. Professor Suk is a legal scholar researching equality at the intersection of law, history, sociology, and politics in the US and globally. She wrote the book on the ERA, literally. Her book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment, is the first and only book to chronicle and assess the 21st century revival of the ERA. We are so thrilled to have you on this panel, Julie.
Great. Thank you so much. It's an honor to be here with my distinguished co-panelists. And I think I was asked to talk about what the ERA could do, why it's still needed in the 21st century. And my answer to that question is really connected up with the ERA's history and as well as the contestation about whether the ERA is part of the Constitution now and what steps are needed in order to legitimize the ERA. As we all know, the ERA is the only amendment that has met the requirements of Article 5, but still has not been added to the Constitution. And the reason it hasn't been added to the Constitution was that Congress put a 7-year deadline on the ratification of the ERA, and only 35 out of the 38 states ratified the ERA within that 7-year time limit. Congress, of course, attempted to extend the time limit once, and it was extended to 1982, but no additional states ratified. As was mentioned earlier, several states rescinded their prior ratifications before the expiration of the original time limit. And we have a handful of states now either talking about rescissions or actually taking votes to rescind in the 21st century, including most recently West Virginia. And indeed, the central argument as to what steps are now needed to legitimize the ERA centers around the legitimacy of the deadline. As my colleague David Posen's work has brilliantly shown, there has been contestation about what Article 5 actually requires and whether those requirements have in fact been met, not only about the ERA, but about almost every amendment that has come to pass in our constitutional history, including very significantly the 19th Amendment, whose legitimacy and the legitimacy of ratification was litigated in the case of Weiser versus Garnett. So within the ERA context, there's certainly a plausible legal argument because of the ambiguity of Article 5 that deadlines are not legally valid. Therefore, if Congress actually does not have the power to impose a deadline on ratification and to constrain the states in the way that it did, it does seem, and that's the theory that is being advanced in the litigation brought by the 3 states, now 2 states, seeking to get the ERA recognized in the Constitution by forcing the archivist to add it to the Constitution. And so by that logic, if Congress doesn't have the power to constrain the states in the amendment process by imposing this deadline, then any deadline that Congress expressed was just advisory and non-binding, and therefore the ERA is part of the Constitution now, and specifically now when we're thinking about the moment at which, by the terms of the text of the ERA itself, it's supposed to be valid 2 years after the date of ratification, which assuming that the ratification occurred January 27, 2020, when Virginia passed the resolution, the ERA would be effective and enforceable as of the end of January of this year. Now, based on this legal theory, the practical realities of the legal world is that even if the ERA is part of the Constitution in this sense, it does seem like its actual ability to do anything in the world is going to depend on the recognition by courts and a range of legal and other actors to deploy the ERA because they regard it as legitimate. And unless it can be legitimized, it won't be able to do the work that its proponents want it to do. And this is a way of saying, even if the archivist were to publish the Constitution now, it would most likely not, publish the ERA in the Constitution now. That act of publication in the Constitution would not be accepted as legitimate by, for instance, the unratified and rescinding states. It's highly unlikely to be accepted as legitimate if the archivist were to do it by the federal judiciary, including, most importantly, the US Supreme Court. And this is where I think one of the very important strategies has centered on congressional action to remove the deadline altogether. And I want to speak to why this is important, not just as a legal matter, right? We could debate about whether Article 5 authorizes Congress to impose deadlines and therefore authorizes Congress to remove any deadlines that it put. And that debate would lead to this question, well, is it necessary for Congress to act in order for the ERA to become a part of the Constitution? Certainly, the historical precedent points to Congress resolving any ambiguities about the validity of ratification. And certainly, Congress played that role with regard to amendments that we now consider to be foundational to our Constitution, specifically the post-Civil War amendments, banning slavery, guaranteeing equal protection of the laws, and guaranteeing that the right to vote would not be abridged on the basis of race. There is also plenty of Supreme Court precedent that suggests that Congress has plenary power over the proposal of amendments, and that power includes certain procedural requirements, including ratification deadlines. So cases like Dillon versus Loss and Coleman v. Miller seem to recognize Congress's power to set deadlines pursuant to its power under Article 5 textually to propose amendments to the states. And Coleman v. Miller also notes that with regard to the question of timeliness, it's really a political question as to whether an amendment remains vital and timely and still needed. And because of the political nature of that assessment, it's best left to the political branches. And of course, Congress is the only federal political branch mentioned in the text of Article 5 itself. And certainly, it would be consistent with the approach of the current executive branch, the OLC, that is, instead of withdrawing what was said in the Trump administration's approach, the current OLC suggested that even recognizing the validity of that 7-year deadline on ERA ratification would not preclude Congress from taking action to change or remove it altogether. So, given where we are right now, it does seem that Congress's removal of the deadline, whether you think it's legally necessary to make the ERA law, it seems that it's necessary, at least in a political sense as well, because there are too many parties in the world who would not recognize the ERA's legitimacy under current circumstances without additional action taken by Congress. And what I want to suggest here is that the process by which Congress removes the deadline, much like the process by which the 3 state legislatures revived the ERA, essentially, Nevada, Illinois, and Virginia, these processes actually matter. And they matter not just for legitimizing the ERA, but for legitimizing what the ERA is meant to do in the 21st century. Because one of the difficulties, of course, of a transgenerational amendment like the ERA is that we can talk about what it does as law in terms of what its framers hoped for in the 1970s. And this is something that I talk about a lot in the book that Ting Ting mentioned, We the Women, where looking at the 70s legislative history, it's clear that they wanted this amendment to the Constitution because the Supreme Court refused to recognize sex discrimination as a constitutional problem in its interpretation of the Equal Protection Clause. And so the ERA is really introduced because it's believed that without the ERA, there is no constitutional route to invalidating laws that are sex discriminatory. Now, of course, the framers talked about other things as well, not just getting rid of sex discrimination and sex classifications in the law, but also catalyzing legislative action to remove barriers that women faced because of gender, including, very importantly, barriers that women faced because they were mothers or because of reproduction, because of caregiving. And those are issues that have continued to cause inequality. And arguably, there has been less legislative action than perhaps one might like in the 21st century to remove those remaining barriers. And indeed, the interesting thing, the delaying of the effective date, which I mentioned earlier, the delaying of the effective date was read explicitly as evidenced by the framers of the ERA's contributions to legislative debates. That whole delay was built in because they wanted the political branches, whether it was state legislatures or Congress, to really think about how they would change laws that disadvantaged women or discriminated against women by making gender classifications. They really wanted the political branches to be the primary enforcers of the Equal Rights Amendment, although certainly the judicial project of scrutinizing gender classifications in the law was also an important part of the ERA's purpose. So one of the difficulties, of course, is that the ERA is proposed by 2/3 of Congress in this context of trying to get the law to forbid sex classifications. That's a project that actually succeeded even with the ERA, without the ERA, specifically because of litigation that was led by the late Justice Ruth Bader Ginsburg as a lawyer. The Supreme Court increasingly recognized sex discrimination under the law as a constitutional problem in interpretations of the 14th Amendment. And so if we were to freeze the ERA's purpose in the 1970s, in the context of 21st century revival, one could make the argument that the 1970s purpose is no longer quite as pressing in 2022 because there were so many other strategies by which feminists achieved some measures of success in changing constitutional law to recognize sex discrimination as a problem. On the other hand, there were other unfinished projects, that is robust legislative action to eradicate barriers that women faced because of motherhood, because of lack of childcare, because of their reproductive capacities. And that project, I think, remains vital today. But in order for that project to come front and center, as opposed to the idea of scrutinizing gender classifications in the law, in order to make that the 21st century goals of any form of constitutional gender equality to be articulated, we actually need a lawmaking process for those goals to come to the fore. And this is why I think, as evidenced by the House's votes to remove the deadline on the ratification of the ERA, which took place in 2020 and 2021, it's clear that those floor debates and the House Judiciary Committee hearings on the removal bill, the deadline removal bill, it's clear that those are the opportunities by which our elected political leaders bring 21st century concerns, including the new disadvantages that women are now facing because of the COVID-19 pandemic and its effects on the lack of availability of childcare and its implications for women's integration into the workforce. It seems that to deal with these 21st century issues, and these are 21st century issues that gender equality amendments in constitutions around the world that were adopted in the 20th or 21st century are dealing with at the level of both legislation and law. It seems that if we want the ERA to have any real relevance to the 21st century problems of gender inequality, we really need a process by which those 21st century problems become the focal point of this amendment, rather than just having a frozen in time 1970s amendment now ratified and added to the Constitution without further elaboration. Without that further elaboration, we'd just be taking that 70s frozen in time amendment and handing it off to the sitting Supreme Court to decide A, whether it's valid, and B, what it means to them. So this is why I do think that not only legally, it's important for Congress to weigh in on the vitality of the ERA, but substantively, if you actually want an ERA that has been worth a multi-generational fight, the process by which it's made really needs to continue and have a 21st century imprint.
Thank you, Professor Suk. I'll start out this discussion with a couple questions, and then I'll turn to the Q&A and pose questions from our participants to the panelists. I'll start out with this. As the presenters have noted, the most recent amendment to the Constitution, the 27th Amendment, was proposed by the first Congress and took over 200 years to ratify. No one's litigating the validity of the 27th Amendment, but it seems that people will make it their life's work to oppose the ERA. Now, we've laid out all the biggest challenges to the ERA. Let's talk a little bit more about the changes that are needed in our laws and our culture and our government that could make these conditions favorable for the ERA's passage. I'll pose that to you first, Julie.
So, well, I'm not sure what to make of not litigating the validity of the 27th Amendment, because I guess unlike the kind of amendment that the ERA is with regard to what it means and the possibility of contestation in a highly polarized society, I think the 27th Amendment is just a very different kind of amendment. But that said, I think it is worth noting just the historical genesis of the ERA deadline and why it's actually not really advancing in Congress at the present moment. So the interesting history of the ERA deadline is that originally the ERA was passed overwhelmingly by almost everyone in the House in 1970. And it was passed very dramatically in 1970 with no deadline in the resolution. When Martha Griffiths got it to the floor by itself an quite extraordinary maneuver, because the chair of the House Judiciary Committee, Emanuel Seller, who's an opponent of the ERA, wouldn't report the ERA out to the floor in the House, even though they clearly had the votes to pass it without the deadline. But because the House Judiciary Committee wouldn't report out the bill, Martha Griffiths actually did a discharge petition, which involves getting like half the House individually to sign the petition. And so she gets it on the floor, but once it actually sees the floor, like the full body of the House, 96% of the House votes to pass it without the deadline. But of course, it goes to the Senate in 1970 after the House passes it. And in 1970, Sam Ervin, who's one of the most vocal ERA opponents in the Senate, uses a filibuster to defeat an amendment that would have abolished the Electoral College. And that's like the big story that happens in the Senate with regard to constitutional amendments before the Senate, like right before elections, gets the ERA. And similar filibuster-like tactics are used by the same people to raise questions and to prolong debate about the ERA, which leads to the outcome of the ERA just never even getting voted on in the Senate. And then it has to come back in 1971. And I think that history is important because the bill that gets passed by the Senate in 1972, passed by the House in 71, Martha Griffiths is pretty shrewd, and she just decides that even though she knows that there's overwhelming support, it's not going to get past a filibuster, and there are some vocal opponents. In the end, in the Senate, there were only 8 guys who voted against the ERA, but she knows that it's going to have, there's going to be trouble getting it to a vote if the most vocal opponents they have substantive problems with the ERA, but one of the issues that they raised was its lack of a 7-year deadline. So I think she sees that as a small concession, and that's a major political miscalculation on her part because she accepts the deadline in part to avert other just more polarizing debates, which happen anyway. And I think that history is important because at the present, we have the House having passed the deadline removal twice now, but in the Senate, because of the filibuster, it's very unlikely to pass, even though arguably there's a majority of the Senate that would be willing to pass the deadline removal bill. And I think it is important as we talk about Article 5 and the process of amending the Constitution and all the problems that David talked about in his earlier presentation, that the problem is that we have this very high threshold and a highly polarized society. The Article 5 imposes a very high threshold. We have a highly polarized society, and we have political institutions that have processes. That is, so state legislatures control the processes of amendment. So the Senate controls its own rules for whether they debate or vote on things. And all of these institutional features make it very easy to block amendments that would actually tend in the direction of greater inclusion. So I think that that's something that we need to discuss in terms as we think about which amendments have had a harder time than others.
Thank you, Professor Suk. I'll start out this discussion with a couple questions, and then I'll turn to the Q&A and pose questions from our participants to the panelists. I'll start out with this. As the presenters have noted, the most recent amendment to the Constitution, the 27th Amendment, was proposed by the first Congress and took over 200 years to ratify. No one's litigating the validity of the 27th Amendment, but it seems that people will make it their life's work to oppose the ERA. Now, we've laid out all the biggest challenges to the ERA. Let's talk a little bit more about the changes that are needed in our laws and our culture and our government that could make these conditions favorable for the ERA's passage. I'll pose that to you first, Julie.
So, well, I'm not sure what to make of not litigating the validity of the 27th Amendment, because I guess unlike the kind of amendment that the ERA is with regard to what it means and the possibility of contestation in a highly polarized society, I think the 27th Amendment is just a very different kind of amendment. But that said, I think it is worth noting just the historical genesis of the ERA deadline and why it's actually not really advancing in Congress at the present moment. So the interesting history of the ERA deadline is that originally the ERA was passed overwhelmingly by almost everyone in the House in 1970. And it was passed very dramatically in 1970 with no deadline in the resolution. When Martha Griffiths got it to the floor by itself an quite extraordinary maneuver, because the chair of the House Judiciary Committee, Emanuel Seller, who's an opponent of the ERA, wouldn't report the ERA out to the floor in the House, even though they clearly had the votes to pass it without the deadline. But because the House Judiciary Committee wouldn't report out the bill, Martha Griffiths actually did a discharge petition, which involves getting like half the House individually to sign the petition. And so she gets it on the floor, but once it actually sees the floor, like the full body of the House, 96% of the House votes to pass it without the deadline. But of course, it goes to the Senate in 1970 after the House passes it. And in 1970, Sam Ervin, who's one of the most vocal ERA opponents in the Senate, uses a filibuster to defeat an amendment that would have abolished the Electoral College. And that's like the big story that happens in the Senate with regard to constitutional amendments before the Senate, like right before elections, gets the ERA. And similar filibuster-like tactics are used by the same people to raise questions and to prolong debate about the ERA, which leads to the outcome of the ERA just never even getting voted on in the Senate. And then it has to come back in 1971. And I think that history is important because the bill that gets passed by the Senate in 1972, passed by the House in 71, Martha Griffiths is pretty shrewd, and she just decides that even though she knows that there's overwhelming support, it's not going to get past a filibuster, and there are some vocal opponents. In the end, in the Senate, there were only 8 guys who voted against the ERA, but she knows that it's going to have, there's going to be trouble getting it to a vote if the most vocal opponents they have substantive problems with the ERA, but one of the issues that they raised was its lack of a 7-year deadline. So I think she sees that as a small concession, and that's a major political miscalculation on her part because she accepts the deadline in part to avert other just more polarizing debates, which happen anyway. And I think that history is important because at the present, we have the House having passed the deadline removal twice now, but in the Senate, because of the filibuster, it's very unlikely to pass, even though arguably there's a majority of the Senate that would be willing to pass the deadline removal bill. And I think it is important as we talk about Article 5 and the process of amending the Constitution and all the problems that David talked about in his earlier presentation, that the problem is that we have this very high threshold and a highly polarized society. The Article 5 imposes a very high threshold. We have a highly polarized society, and we have political institutions that have processes. That is, so state legislatures control the processes of amendment. The Senate controls its own rules for whether they debate or vote on things. And all of these institutional features make it very easy to block amendments that would actually tend in the direction of greater inclusion. So I think that that's something that we need to discuss in terms as we think about which amendments have had a harder time than others.
Yeah, just building off what Julie was saying, I mean, I think what Professor Sook was saying, I mean, I think a lot of the challenges that the ERA has right now are political in nature. You know, the ERA started out as bipartisan and was overwhelmingly supported, and few people even today contest the actual text of the ERA. Very few people say that they disagree with the exact contents of the language of the ERA, but it's been brought into the kind of culture war sphere and made into something much more than what just the text of the amendment actually says. And I think it feeds into some of our country's struggle with equality as a whole. I mean, there are some people who come at these issues with a perspective of equality as a zero-sum game. And there's this feeling like bringing more people under a tent takes away from others. Even though research undercuts that, the idea that the more we bring people under the tent and the more people are treated equally, that the more we rise as a society. But I think some of it, the fact that the ERA has been brought into these bigger culture war issues, is the political challenge that the ERA faces right now, because the text of it should not be controversial, and polls show that the overwhelming majority of Americans really do support what the text of the ERA actually says.
Maybe I'll just say briefly on the 27th Amendment piece. I think I agree with everything that was just said, but I think the 27th Amendment should give heart to ERA supporters in that my own view is it has a much worse case for compliance with Article 5 than the ERA. I just looked up the language from the Dillon opinion by the Supreme Court in 1921 when it was dicta, but the court said that the fair inference or implication from Article 5 is that ratification must be within some reasonable time after proposal, which I think is a plausible take on Article 5. And then went on to say that it's quite untenable, that's the phrase, quite untenable, that what we now regard as the 27th Amendment could be revived by some future generation. So why has the 27th Amendment not been challenged more? I think there's a difficult question about who would have standing to challenge it, for one thing. And for another, it's hard for Congress to be seen as opposing an amendment that limits, congressional pay increases. It's not that consequential an amendment in the life of our country. So for a variety of reasons, the 27th Amendment was just insulated from some forces of backlash that might have exposed the really significant problems raised by an amendment proposed over 200 years before it gets ratified. But it does go to show that we've been willing to overlook those kinds of problems in the recent past. On the politics of the ERA now, I don't have much to add except to say that it's not the case at this moment that the legal community broadly acts as if the ERA is the 28th Amendment. We're not there yet. But I think the history I discussed suggests that there's never, or very rarely, a clear magic moment when that happens, when an amendment passes over the threshold of legitimacy to being recognized as in the Constitution. A court decision could certainly help a lot. It could also hurt a lot if it goes the other way. But it's really just the combination of various diffuse legal actors all acting as if something's in the Constitution, and eventually it comes to be treated as such. So I think anything that happens, especially in Congress, but anywhere where government officials are moving the ERA toward recognition of the 28th Amendment is positive. And so even if in the Senate, partisan politics or outright opposition to the ERA on the Republican side or the filibuster get in the way of a decisive 60+ vote, in favor of eliminating the deadline, say, I still think it's useful to have a majority of the Senate, if it's there, voting to advance that kind of bill, just as one more indicia of official governmental support for the ERA being the 28th Amendment. And I guess I would be inclined to try to put Republican senators to that vote. You could even do a carve out from the filibuster specific to constitutional amendments in general, or the ERA even more specifically, to try to force that vote, or make the filibuster vote a proxy for a vote on the ERA as one of the first steps to advance the ERA in government.
Thank you, everyone. I will just follow up on that conversation. Let's stick to the kind of constitutional question about legitimacy here. I think the question about the ERA and the political process is situated in a larger conversation about our democracy and what it means for everyone to pose something so universally accepted. Article 5 sets a very high standard, almost kind of a double supermajority standard in terms of what Congress has to do and then what the states have to do. And then, as you all discussed, with the deadline to the joint resolution to lift the deadline of the ERA in the House, which is now kind of sitting in the Senate without any action, SJ1, the filibuster, in a sense, imposes a third supermajority requirement to the ERA. Seems incredibly unfair, but beyond that, just kind of democratic. I'll pose this to Professor Posen first to speak about this concept.
Well, I think Article 5 is a horrible amendment rule, and so we're feeling it, the burn of it.
Tell us how you really feel.
Most political scientists rate it as the single most difficult amendment threshold in the world. Donald Lutz, in a famous study, said that the Yugoslav constitution had a harder amendment procedure, but that constitution is now defunct. And we have, I think, something like the third least frequently amended written constitution of any democracy in the world, behind only, I believe, Japan and Denmark. So we have an extraordinarily difficult to amend constitution that is extraordinarily rarely amended. And this creates all kinds of democratic pathologies, including how much we look to the courts to do the functional updating of this text. So just as a background matter, I take the point and think Article 5 is a terrible provision. What does that suggest for how to deal with it? To me, it suggests that we should be open to flexible and creative interpretations. If we're stuck with this basically anti-democratic amendment rule, we can at least try to be permissive where it gives textual and historical permission in the way we read it. So I've suggested in the article that I was talking about earlier that we have a default posture of where Article 5 is ambiguous, reading it in favor of allowing amendments to go forward. That's one way to kind of whittle away at the constraints it opposes, even if only on the margins. So kind of an interpretive, very modest solution to what's a fundamental structural problem. I guess last thing I'll say, which complicates the story a bit, is there's this fascinating finding from the comparative political science literature that the formal difficulty of a country's amendment rule doesn't actually correlate very well with how often that country amends its constitution. In the US, it does. We have a difficult rule and rare amendments. But there are some countries that have difficult amendment rules and actually amend their constitution quite a bit, and some countries with pretty easy amendment rules that don't amend their constitutions very much. And a number of political scientists suggest that even more important than the amendment rule, therefore, is amendment culture, and whether a country is just in the habit of, and its politicians are in the habit of thinking that amendment is a viable option, for the country. And there too, it's hard to engineer this, but on the cultural side, I wish we would get to a place where we are all more comfortable with amendments, maybe even with constitutional conventions, to fundamentally reconsider the document periodically. But if we could kind of destigmatize or take away the sense that there's something extraordinary and worrisome about amending the document, that could help too. But these are kind of moves on the margins, and just fundamentally with the premise of your question that Article 5 is a very unfortunate feature of our Constitution.
Just one anecdote to kind of build off that. Apparently in 2014, Justices Ginsburg and Scalia were both asked how they would amend the Constitution if they could. And Justice Ginsburg said she would want an equal rights amendment. And Justice Scalia said he would want to amend Article 5 to make it easier to amend the Constitution. So I think it sheds an interesting perspective on this issue, both also where we are, because substantively, there's the idea behind the Equal Rights Amendment and whether people agree with it and what that means for our society, but then also the bigger picture. And this was part of the big strategy of the three states litigation, was having a hyper-textualist, hyper-originalist reading of Article 5 that's true to what the founders believed, which was that the amendment process needs to be meaningful. And the more we interpret Article 5 to be impossible to actually achieve, the more we are straying from what our founders intended. And so if there's any kind of glimmer of hope, at least for the litigation, it's that if judges who are encountering the case or justices stay true to, if they purport to be originalists or textualists, if they stay true to it, the litigation gives them an avenue to really read Article 5 in a way to recognize that the three states ratifications were indeed valid and mean that the ERA right now is part of the Constitution. I think the struggle is what everyone already spoke about, because people didn't immediately act after Virginia's ratification, like the ERA was part of the Constitution. That puts us in a different position right now, 2 years out, than we would have been. People really struggle with the idea of taking something away as opposed to giving something to them. And so we're just, from a political standpoint, on very different footing than we were this time 2 years ago.
So I just want to add to this. I mean, I came into my work on the ERA as a comparative constitutional law scholar, following up on many gender equality amendments that were adopted in European countries in the late 1990s and the early 2000s. And that really did shine a light on what are their amendment processes as compared to ours, as well as what are their amendment cultures as compared to ours. And I think another part of the ERA story that we don't shine enough of a light on is the assumption that state legislatures have complete control over the process over which they amend federal constitutional amendments, even though it's widely recognized that they are performing a federal function. But a clear story with regard to why Illinois couldn't get the ERA ratified in the 1970s, but did really by a very marginal vote in 2018, is that Illinois has long had this rule that you need 3/5 in the state legislature to ratify a federal amendment. And that's pretty anomalous. Most states will just do a majority. And the story in Virginia also is that it was always up to the Privileges and Elections Committee whether the ERA advanced to the floor, as compared to perhaps an alternative rule that says that a federal constitutional amendment must be considered by the state legislature at a particular time. But throughout our history, we've given the states a lot of control, and some of that has led to supermajority requirements even at the state ratification level, which arguably make the Constitution harder to amend than what you might think is envisioned by the text of Article 5. So I do think that we need to, so one strategy is, as a judicial matter, if there are opportunities to read Article 5, which is ambiguous in a way that tends towards change as opposed to against change, maybe that should be just an approach to the reading of that textual provision. The other thing is that I guess there's a lot going on with regard to if Congress can actually impose deadlines pursuant to its proposal power. We might try to think about what other things can Congress do pursuant to its proposal power that might make it easier or more democratic to amend the Constitution. So one thing that's been super interesting is watching the process by which the Irish have amended their constitution in the last few years around basically liberalizing access to abortion as a constitutional amendment. And this happens because of the people's participation. Even though the rule is Parliament adopts and then the people ratify in a referendum, Parliament actually created citizens' assemblies, which were advisory in nature. So they weren't delegating the proposal power to the citizens' assemblies, but these are randomly selected people the way that we randomly select juries who deliberate and make proposals to Parliament. And I think that had a hugely legitimating function and really put Parliament in a position where it was very hard to ignore the recommendations of the citizens' assemblies. And then, of course, it succeeds in referendum once Parliament adopts. But I have wondered, not just conventions, which are explicitly authorized by Article 5, whether the proposal power could also be read a little bit more broadly to authorize Congress to use popular and more democratic processes in an advisory capacity around amendments that it seems like most of the American people support.
I wonder if we can talk about perhaps what state ERAs can offer us by way of hope. We've so far diagnosed the real hurdles, not insurmountable, that are standing in the way of getting a constitutional ERA. But what gives me hope is that there are 26 state constitutions that guarantee explicit sex equality. Can you each talk about how state ERAs can advance gender equality in their own right, and additionally further inform us or show why a federal ERA is so needed? I'm going to call on Michelle.
Sure. So a number of states do have ERAs, and a lot of them have been essentially interpreted to be either lacking much meaning or coextensive with our current understanding of the 14th Amendment. So I guess in one respect, and I think Professor Silk spoke about this a little bit, I mean, we've achieved a lot through interpretation of the 14th Amendment, what part of the aim for the ERA was in the 1970s. That said, given where the Supreme Court currently is, given what's happened with regard to stare decisis, I don't think we should be at ease to assume that the interpretation of the 14th Amendment as it stands today is going to be, it's going to remain that way forever. Particularly from an originalist standpoint, I don't think anybody thought that there aren't many originalist scholars who think that the current understanding of the 14th Amendment is the proper originalist meaning of the 14th Amendment and its scope. So to the extent stare decisis is a little bit on shaky ground, to the extent that we're going to have the Supreme Court looking at 14th Amendment jurisprudence at some point, again, fresh from a different perspective, I don't think that jurisprudence is as safe as some people might think. And so to the extent that that jurisprudence is come back on, we can look at state ERAs to vindicate some of those interests. There has been a little bit of development. So some of the opponents to the federal ERA effort have looked at case law in some states. So for example, there's a New Mexico, I think it was the New Mexico, I don't recall if it was a New Mexico Supreme Court or a lower court in New Mexico, but kind of interpreting New Mexico's ERA and what it means for abortion. And that was used as a basis to kind of tie in, to oppose the federal ERA, to say that it really is directly tied to abortion. And so that case was used as an avenue to kind of bring the ERA into the culture war ambit more. And so I don't know that looking to state ERAs currently as they stand is going to do a lot, but there might be some potential in the future.
Well, I think historically, a lot of state apex courts haven't been particularly imaginative with the way that they interpret their state ERAs. Virginia has had a state ERA for quite a while. And I think that very often jurists at the state level just say they're just going to rely on and cite equal protection jurisprudence as a way of interpreting their own state's ERAs. And the exceptions that we see is that a few states, Connecticut, New Mexico, I think maybe Alaska, the Supreme Courts have interpreted their state ERAs as requiring the public funding of medically necessary abortions. And that's played in interesting ways in further debates about whether a federal ERA is desirable. But I think that, and so I think there is potential to read the state ERAs more expansively, both with regard to reproductive healthcare access, as well as perhaps disparate impact theories of liability under state ERAs. But that said, I think that the bigger problem might be that if the federal equal protection clause is read by the sitting Supreme Court in a particular way, there might be that might actually limit the way in which state ERAs could be read. So I'm thinking specifically about the context of affirmative action. If the US Supreme Court says that having like gender quotas for corporate boards, for example, is to be strictly scrutinized and strikes those things down, then I think that a more expansive understanding of what a state ERA requires or even permits could be preempted by federal equal protection jurisprudence. And so I think it is important, whether it's done through equal protection clause or through ERA, that the substantive visions of equality be worked out at the federal level, not only the state level.
I don't have much to add. I think Julie is the authority on state ERAs. Happy to talk about other matters, but maybe I'll.
Thanks. So as a constitutional amendment, the language of the ERA is necessarily broad. I'd like to know what you guys think about the process of meaning making that will need to take place so that we can have a substantive vision for the ERA and a feminist ERA that's not like the 14th Amendment. And maybe to take it a step further, I wonder, Section 2 of the ERA gives Congress the power to enforce it. You can also go into the potential of that kind of a section. I'll start with Professor Suk here.
So I think that there's great potential that Congress's power to enforce the ERA under Section 2 could be read more broadly than the way that the Supreme Court has read Section 5 of the 14th Amendment, the Congress's power to enforce the Equal Protection Clause. That has been criticized in the gender context, specifically because of the Morrison case in 2000, which struck down as exceeding Congress's power under both the Commerce Clause and Section 5 of the 14th Amendment. This is the provision of the Violence Against Women Act that created a civil cause of action in federal court for victims of gender-motivated violence to sue their perpetrators. So I think it is certainly plausible and compelling to suggest that the ERA involves a much more expansive understanding of congressional power. But I don't know if that's true textually, right? It just says Congress shall have the power to enforce, and the ERA just says equality of rights shall not be denied or abridged on account of sex. So is it obvious that Section 2 would definitely authorize the civil rights remedy in VAWA? Well, it depends on whether or not a court decides that they want to read Section 2 of the ERA parallel to Section 5 of the 14th Amendment. And I think one thing that could go into a court's decision, although it depends on the methodology of the judges, is legislative history surrounding the scope of Section 1 of the ERA. If it's very clear that Section 1 of the ERA speaks to a range of forms of violence against women or reproductive health care injustice, then I think that judges should feel compelled to read Section 2 more broadly than they read Section 5. But I don't think that with the text that you have and a frozen in time amendment from the 1970s, I don't think that gets us there, which is why I think it's so important for the political process of legitimizing the ERA to continue.
Okay, so the ERA also does not explicitly mention women. So in that sense, it's for everyone. My question is, how can a modern ERA be an effective tool to dismantle discrimination beyond sex and gender? And the next panel will go in depth into the 14th Amendment and its relationship to the ERA. But from a race discrimination perspective, the 14th Amendment's strict scrutiny standard, has not been particularly useful in dismantling racism in America, and perhaps definitely has been in fact used as a tool to undermine equality. So from that perspective, also in what ways could the ERA be used to strengthen race discrimination too?
Maybe I'll go, Tinky, but I don't think I have a good thought on how it could be used to strengthen used against race discrimination. I guess I have a hard time seeing how this court would draw that link. I'll instead just say something a little, step back and say, I think the ERA will pose a real interpretive puzzle for this Supreme Court if it's recognized as the 28th Amendment, because for the first time, we have a majority of the justices who self-identify as originalists in how they say that when they're asked to interpret any part of the Constitution, they look at the ordinary public meaning of the words at the time the provision was framed and ratified, and that there's assumed to be no daylight between framed and ratified. There's just one public meaning at this moment in time when the language emerges. But in fact, in the ERA, the time the language was framed in the early 1970s to the time when, if the theories are accepted, it's been ratified just recently. I think the ordinary public understanding of its words has evolved, particularly around what sex means. And there's some clue to this in the court's statutory opinion in the Bostock case, where Justice Gorsuch understands discrimination on the basis of sex to encompass discrimination on the basis of sexual orientation or gender identity. And so he kind of elides this problem by going with the more current understanding of what the term sex encompasses, but he loses Alito and other justices who find that implausible. So I think it's a conundrum for originalists to think about language whose ordinary understanding has not been stable in the ratification window itself, and that means it's just very unclear to me what the court will do with understanding sex in particular. That said, the kind of vulgar legal realist in me is just skeptical that this court would do much of anything really exciting with the ERA, which, as Julie says, has language. The enforcement language is parallel to what we see in the Reconstruction Amendments, and the court has already interpreted very narrowly what Congress can do with its Reconstruction enforcement powers. So, okay, but I'll leave it at that. I don't have a good answer on race. I do think sexual orientation discrimination and gender identity discrimination are the most obvious frontiers on which the ERA could be pushed, and maybe ones in which this court would even get there, because unlike the Equal Protection Clause, the word sex does appear in the text of the ERA, and so the Gorsuch move in Bostock seems readily available.
Yeah, I think there are a lot of theorists who've assumed that recognition of the Equal Rights Amendment means that strict scrutiny is going to apply moving forward to sex-based discrimination. And while that it could potentially be something that happens. There's no guarantee. I mean, there's nothing in the ERA that says, strict scrutiny hereby applies moving forward. And so one thing that could happen is that the Supreme Court could read the ERA to just apply intermediate scrutiny, and I guess essentially a little more explicitly constitutionalize what we currently understand to be what the 14th Amendment does. And so that's one avenue in which the ERA would be part of the Constitution, but wouldn't really change the legal landscape as it stands right now. They could impose some other test to see whether or not the ERA is violated that we don't know of right now, but we don't have any way to kind of know that race-based discrimination analysis is going to map on to how the ERA is interpreted. I did have one thought, though, about what the ERA would mean from a race discrimination standpoint beyond just kind of potentially looking at the test, the legal test. I think it bears emphasizing that women of color in the United States in particular have been victim to some of the inequities in society more so than any other group. And I think the maternal mortality rate is a clear example of that. And so to the extent we are having these conversations in our society about inequities, I do think that some of the things that can be highlighted, in particular, some of the experiences of women of color in the United States can be part of that conversation and can help emphasize why the ERA can make a difference, if not legally, which it very well could, but also just in terms of our society, where we've been, where we are, and where we want to head.
Well, I think it is important to make the process point here because assuming an originalist understanding, the ratification, it's not like we had states ratifying continuously for 40 years as that public meaning evolved. We had most of the states that ratified the ERA ratified 70s understandings of sex. And then we have 3 states where it's actually explicit in Virginia's ratification that there's an explicit discussion of gender identity and sexual orientation in the House of Delegates. And much more attention in all 3 ratifications to intersectional understandings of what sex discrimination is, led by understandings of how race and sex intersect. So arguably, by the time we get to the last 3 ratifications, there's a transformed just intersectional and fluid understanding of sex, but that's only 3 states. And you have 35 states that ratified with a different understanding of sex. And this is why I think a congressional conversation, that is a national conversation about that meaning in the context of removing the deadline is so important because the public meaning, the way in which the public meaning evolved is so kind of erratic and uneven as a national matter. And so if we want to consolidate a 21st century meaning, I don't see how it can be done without a congressional affirmation of the commitment to the ERA.
Thank you. The ERA poses questions that are unanswered, and in a lot of senses, it's very legal and highly technical. And I'm wondering if you guys can speak about how we can tell the story of the ERA, which fully credits the women and the people who have been involved from the beginning, especially how to center the voices of people of color in this conversation. But, and maybe this is an inappropriate thing to wish for in kind of like a legal historical perspective, but, how do we tell the story that centers people's lives?
So I'm sorry, I'm going to jump in now because I'm looking at the clock and I have a 12:40 that's in person that I have to go speak at. But I'm just going to say that this is why I wrote a book, We the Women, which it engages some of the legal issues we've talked about, but it really tries to tell the story. It tells a 100-year transgenerational story. So I hope people will read it. But in addition to just I've sort of given it a narrative, but I think people should engage with the legislative history at various moments. And I think that's where we can learn a lot about how the 21st century meanings and the women and so much of what's important about what we're doing with the ERA is not just what it's going to do as law, but recognizing the people who made it as constitution makers. If that text doesn't get into the Constitution, they are not founders and framers. They are activists. Whereas I think if the text gets added to the Constitution, we can actually say that we have female founders and framers in an official way. And I think that's huge. And it's huge as to how we tell the story of who we are as a nation. And I think that's actually the most important argument, not strict scrutiny or any of the other legal issues that we've discussed. But with that said, I'm very sorry I need to hop off the call now.
Thank you so much, Professor Suk. Okay, and then there were two. Well, I have more questions. I want to ask some questions from the Columbia Journal of Gender and Law students. First is, since amending the Constitution is one of the hardest things to do, if not the hardest, to accomplish in legal reform, is focusing on the ERA realistic, or should the focus be more on reforms that are more straightforward to implement?
I think realistic is in the eyes of the beholder, but the fact that we're having these conversations in and of itself is important. And thinking about the history of our country, looking at our Constitution, not just accepting, we all have in our mind what the founders look like, what the framers look like. And I think one of the reasons why the show Hamilton was so successful is because it upended some of that. And so doing that then from kind of a gender perspective and recognizing, thinking about what Abigail Adams asked of her husband, she asked to remember the ladies. And at the time the Constitution was being drafted, it wasn't just a given that women were completely left out of these conversations. And so the fact that women were left out of the process and remained out of the process for so long is something that's important for us to grapple with. And so I think just the process of having these conversations, the process of looking at our Constitution and asking what's missing and asking ourselves, do we want our children to pick up a copy of the Constitution and not see sex equality explicitly recognized in there? That in and of itself is an important conversation that can be had that then can maybe move the ball forward, both on recognition of the ERA, but on other things in our society. And so if we look at that a little more broadly, maybe that's a hopeful way to think about these conversations.
Great. Let's see, people want to know more about the deadline and how Article 5 is silent on deadlines, and the ERA deadline was actually placed in the preamble and not the text itself. And so when it was sent to the states for ratification, they in fact didn't vote on the deadline. And also the question of whether the deadline is also in violation of the 10th Amendment.
Maybe I'll just say briefly here that constitutional scholars are, I don't think there's any consensus on these issues. I think it's debatable, like so many Article 5 issues. Some constitutional scholars take the position that if a deadline is included in the operative amendment language itself, as has happened with some prior amendments, that can be binding, because the very thing that the states are voting on to potentially be added to the Constitution incorporates a time limit, and that the ERA is distinguishable because the deadline appeared in an accompanying resolution, not in the text of the ERA itself. I think that's a plausible position, but I guess I don't really have a firm view myself of the best answer, other than to say that it's genuinely unclear. I don't see a 10th Amendment violation that has independent force from the primary question of whether under Article 5 Congress can set a deadline not in the amendment. But in any event, I think it's a tough question, and I don't think there's a clear answer, and I don't have a clear one.
Yeah, just to jump in on that too. I mean, I think the question of the deadline can be organized in two ways. One, the argument that deadlines themselves are unconstitutional as a whole, no matter where they are. I think that argument from a potential of winning in court is a bit of an uphill climb and can be more challenging to make than the more nuanced point. In particular, because the Supreme Court has already held that the existence of a deadline in the text of an amendment itself does not invalidate the entirety of that amendment. That's a different question than whether the deadline itself is operative. But the fact that we've had numerous prior constitutional amendments with deadlines makes it much less likely that a court is going to declare that those amendments themselves, that there's something unconstitutional in those amendments. So that's kind of a practical point about the broader unconstitutionality of deadlines as a whole. The more narrow question with regard to the ERA is whether a deadline in the proposing text of an amendment is binding such that it invalidates subsequent state ratifications. And that's different than the question of whether the deadline in that text is void, for example. It could be read as Congress, setting an internal deadline for itself or recommending a time frame, which is different than the question of whether that deadline invalidates state ratifications. And the theory of the states in the 3 state plaintiffs, well, now 2 state plaintiffs in the litigation, is that if Congress wants to set a deadline, the way that it's done so in the past has been in the text of the amendment. And what's meaningful about that is that the way it would work is that ratification of a constitutional amendment after the deadline in the text of the amendment by a state, I don't see what political reason a state would have to spend time and effort ratifying in that situation. But let's say a state does, it would mean that by virtue of its own ratification and the text of the amendment itself, it's just inoperative. And that's kind of read consistent with the language of past constitutional amendments. It's essentially a vestigial part of the Constitution by its own language. And so the theory of that approach is that it respects the proper balance. It doesn't give Congress more authority than the text of Article 5 provides. It maintains the equality between states and Congress as laid out in Article 5.
Okay, thank you. I'm getting some questions about how brilliant everyone is, but also very kind of lawyerly. The question is, how can lawyers, as both aspiring lawyers and established lawyers, support the ERA and help activists in the work that they do on the ground?
Well, I think one thing good lawyers do is they do a good job of translating their work, even if it's complex constitutional analysis, in a way that's digestible to anyone. And I think, a lot of justices and judges take pride in being able to write opinions that anyone can pick up and read and understand. So I think a challenge and I think goal for us lawyers is to help work with advocates and activists in a way that explains and helps work together to understand what the best, to the extent there's a legal strategy and litigation strategy, how it might play out and what the arguments will be and why certain judges may or may not rule in certain ways, or once their decisions come out, what that means moving forward. And then the activists can take that and decide their strategy in, hopefully consistent with that.
That sounds very sound to me. I just add that I think also a challenge for lawyers here is focusing on different venues than lawyers are used to operating in. So, I already stated my position of basic pessimism about litigation as the avenue to get the ERA recognized. That there are numerous hurdles that judges would have to get beyond to find the ERA in the Constitution, from the deadline question to the rescissions being deemed to be ineffective, to standing and justiciability issues in some of the cases. And then you have just the ideological composition of the federal judiciary today. So there may still be value in certain litigation efforts here, but I don't think it's the primary way in which the ERA is gonna advance. And as I said earlier, I think really Congress is where much more of the action is, and I know Julie's taken a similar view. If that's right, then lawyers need to be redirecting some of their energies toward Congress, which is a harder body to know how to interact with and impress one's views upon. But Congress, I think, can't be let off the hook on the ground that it did its part in the 1970s, and now it's up to the courts or the archivists perhaps to make this thing stick. Congress at the back end, as on the front end, is actually, I think, the key institutional actor here for telling us what's in the Constitution. It took action with the 27th Amendment to recognize that it had become part of the Constitution, even though, as we discussed earlier too, that was very contested. So I guess I would also just call for legal and political and movement engagement in the congressional sphere, trying to force votes in the Senate in particular at this time, in addition to and in some sense even ahead of the efforts being directed at the courts and the archivists.
Thanks, and I just want to put a plug for the ERA project. The reason why we were created was to provide that careful and deep legal analysis, but also to marry that the legal perspective with work that's happening on the ground. And we rely on our sort of constitutional law experts, but we also have many ERA partners on the ground doing the necessary work. So I would direct everyone to our website to check out our work, especially our explainers and our briefs, and to stay tuned and sign on to our newsletters. Thank you so much for this incredible conversation, and we are grateful for the work that you guys do and will continue to do in this fight for the ERA. Any concluding thoughts before we sign off today?
Just the thank you all. I mean, it's really exciting to see how many people are here and interested and engaged and listening, and it's really an exciting time to be doing what we're doing. And I know that like a lot of people took interest in the ERA after Mrs. America came out. And what's fun to see is how so much of what the conversations that were being had in the 1970s, how they've changed, but how so much of it remains the same, and how these things are important to just who we are as a society, where we are. And so it's really wonderful to see how many people are engaged, and really thank you to all the work that the ERA project does.
I'll conclude with a similar note of thanks. It's inspiring just to be in these conversations and feel the energy. And just to the question, we didn't get to every nuance of Article 5 of the ERA. Hope people will email. We could keep talking about it throughout the day tomorrow. But on the question that was asked by students, I gathered from the journal, the Columbia Journal of Gender and Law, about is this realistic? I just want to maybe end by noting that I think the ERA is a more realistic prospect than any number of other things we might want to achieve by way of progressive reform in this country right now, because what the conversation now builds on, so many decades of work by people before us. So the ERA is actually within range, of becoming the law and potentially catalyzing much overdue reform. So I guess I would say there's no cause for despair about the ERA's possibilities and potential right now. There is cause for despair, I think, about a lot of other features of American democracy. But this is an area where lawyers, I think, can actually make a difference in getting this over the line and then using the ERA in the short and medium term. So I hope students don't feel discouraged by what we've been discussing today. But thank you again, Ting Ting and everyone for.
Thank you for ending on this hopeful note. I want to thank our distinguished panelists again and our participants for joining us in this lively debate. I hope you will join us for session 2 on the ERA and the 14th Amendment's gender equality jurisprudence. We'll see you all back here at 1:30. Thanks.